guns, and money. Send lawyers, guns, and money.
Welcome back to Conduct Detrimental, episode number 57. That's Byron Hunt. And if you have to ask who Byron Hunt is, you are definitely under the age of 35. He's the former backup outside linebacker to Lawrence Taylor and Carl Banks. And of course, my cohort and co-host Dan Lust would know that very well because he worked for the New York Giants for a number of years before he attended law school. Dan, welcome back. How are you?
Who's Byron Hunt, Dan? I'm not familiar with this. I thought that was the rule. If you're under 35, you don't know who Byron Hunt is.
He was one of the best linebackers in the NFL who no one ever heard of because he was buried behind LT and Carl Banks on the depth chart. They were two of the greatest linebackers ever to play the game. And during the 1980s, there was no such thing as free agency. So if you were Andy Hedden or Byron Hunt, you basically remained a backup for your entire career because there was no way Carl Banks or LT were going to ever be displaced. So
is it possible, Dan, is it possible that they just were like the ultimate backup quarterback that you never got to see any of their flaws because they were always behind on the bench?
Hunt would have been a starter on most teams, and with no free agency, he was denied that opportunity. Well, anyway, for our 57th episode of Conduct Detrimental, I think it's going to be an especially action-packed episode. There have been a lot of stories breaking in the world of sports this week that touch upon the law. So, Dan, what do you think? What should we hit this week?
So I do think we've got a nice slate today. And we also have a special guest. That's Katie Strang from The Athletic. She's going to help us dive into this Mike Milbury issue. So we'll leave that fourth on the docket. For those that don't know Mike Milbury, we'll say he's had some questionable comments, whether or not in isolation they should have maybe caused a stir and some firing. It's one thing, but Katie's going to talk about a little bit of the history behind those comments. So we'll definitely get into that with her, Dan's colleague over at The Athletic. So on the docket today, the story I found to be most interesting this week is a story I've been tracking for a couple of months. That's the story with Masai Ujiri. That's the general manager of the Toronto Raptors, has been involved in civil litigation relating to an assault. So there was, we'll say, a very big development this week. So that's number one on the docket. Number two is Earl Thomas over at the Baltimore Ravens. I gave one of those alarm emojis because they said the name of the podcast, Dan, Conduct Detrimental. And that term is going to be at the center of a very expensive, we'll say, grievance or a battle over a couple millions in guarantees. And last but not least for us, our third topic before we kick it over to our guest, Katie Strang, we're going to talk about Bob Kraft. We have a decision on the appellate front. So, Dan, that being said, let us start with Masai Ujiri. Just a quick background for those not following the story. Masai Ujiri is the general manager of the NBA champion Toronto Raptors. So it's not just that Masai Ujiri is the general manager of the Raptors. Important for the story, he's an African-American. He's one of the very few in the NBA. So last year during the 2019 finals, Toronto Raptors won the NBA championship. I believe it was game 6, but they won in Golden State. So they won at the arena. So there's a video that was not available to us until this past week, but a video that shows Masai Ujiri after the Raptors won, Kawhi Leonard, Kyle Lowry, they're all celebrating on the court, and Masai is trying to come onto the court. And before he gets to the court, he's stopped by a security guard. So Mr. Strickland, who's a plaintiff in this case, stops him. There is an altercation that ensued. Dan, we'll talk about the video yet. I'll leave that for you. But as a result of this incident, Mr. Strickland was alleging personal injuries. He alleged that he was assaulted. He alleged that Mr. Ujiri was the aggressor. Mr. Strickland, I think important for the story, is a Caucasian. And that was the lawsuit. It was an assault lawsuit. Masai Ujiri was being hit with allegations of assault, causing injuries to Mr. Strickland, that he wasn't able to work. And that's really where we're at for about a little over a year. So, Dan, let's fill our listeners in. What's the new development and where we go from here?
Yeah, sure. Well, it underscores the importance of discovery in federal court litigation. I mean, the lawsuit that was filed by Alan Strickland alleged Ujiri pushed him twice and initiated the contact. And of course, Ujiri, in his answer and affirmative defenses, painted a somewhat different story, that the aggressor was the security guard. So one of the wonderful things about our litigation system is that both sides get a chance to test the veracity of the other side's claims. And the body cam that was on Officer Strickland, I don't know if he was uniformed or not that night, because it seems
he was.
He was in uniform and I guess acting under the color of state law by being an Alameda County Sheriff's Office deputy. He was wearing a body cam while he was on duty. And the tape from that body cam must have been requested by Ujiri's legal team during discovery. And the reason this is surfacing so many months later is that that's how discovery works. It takes, you got to file requests for production and there are little ensuing battles over whether something should be discoverable. But the videotape bolsters Ujiri's assertion that he was not the aggressor, that it was the security guard, it was the officer who shoved him twice.
I'm going to go one step further, Dan. It doesn't just bolster Ujiri's case. It just shows that Ujiri didn't push him twice. There were clearly two pushes, but from the other side. It's just almost as if Strickland just said the other version of events. He said that Ujiri pushed him when it was actually Strickland clearly being the aggressor twice before anything happened.
Yeah, well, I think you're right. But what this really kind of, highlights is the procedural posture under which this arose. Ujiri's legal team filed not a new lawsuit, not a new answer, not a counterclaim, but they asked the judge overseeing the case for permission to file an amended answer and counterclaim. And the reason they did that was that this case is pretty far along. And there are usually in federal court cases, these case management orders, which set out a lot of deadlines and timelines. And usually there's a hard and fast deadline in which to file amended pleadings. And in this case's case management order, it doesn't provide any kind of date certain. It just simply states that amended pleadings shall be upon good cause only. And I would think, given the substance of what the videotape shows, it would certainly establish, at least in my mind, good cause. But the other consideration here is that the trial of this action and all of the important benchmark dates in this lawsuit are in 2021. I mean, you and I have litigated not against each other, but we've had our fair share of...
Not yet, Dan. Not yet.
Not yet, but we're working on it. But our, experience, or at least my experience, has been that in most straightforward federal court litigations, they are on a standard track where you get 6 to 9 months for discovery and a trial, roughly a year after the commencement of the lawsuit. But check out the case deadlines in the Ujiri Strickland case. The trial isn't scheduled until December 2021. The discovery cutoff date is in April of 2021, and dispositive motions are due in July of 2021. So what that tells me is that lowers the bar significantly for Ujiri's motion for leave of court to be granted, because not only does the substance cry out for good cause, but I think the very relaxed schedule in which this lawsuit is proceeding really leaves ample time for the parties to pivot, with this new information without unduly prejudicing other side or unnecessarily delaying the court schedule.
So a couple things, and I think it's important to note, Dan, I've been following this. It's probably about a year since this has kind of come on our radar, maybe a little bit less, maybe November of last year. There was a period of time where I did a couple media interviews. The video wasn't coming up, and I know there was some indication that maybe the video wasn't available. The body camera footage wasn't recording. The body camera footage had been deleted. I'm not sure why that was out as potential reports, but just kind of important to note there's a concept in the law called spoliation. To the extent that you have some type of evidence and you delete it or you dispose of it or you overwrite it, that's what would enable you to get an adverse inference in the case. So I'm not sure necessarily why that was out, but I guess important. Don't believe everything you read in the media. I mean, this is not coming out till a year into litigation. So as part of this motion and this request to file a counterclaim, Ujiri doesn't really hold back. And I posted at least a little snip of the counterclaim on my feed. I'm just going to read you a first sentence. I mean, this is when you bold and underline something, that's then you want the judge to pay attention. I'm just going to read you paragraph 2 of the counterclaim. Mr. Strickland's version of the 11-second encounter he had with Mr. Ujiri after Game 6 is, in all respects, a complete, that's bold and underlined, fabrication. So when you use words like that, Dan, and we've talked about this kind of on the Zion Williamson front, this is getting very close to something that should, and you would know better in terms of federal litigation if you can get it, but where costs should be available to the other side. If this is a complete fabrication and you delayed in giving over the video, I can't imagine a better situation where that in theory should be available.
Well, you raise a great point, and it leads me to my next question I'm going to pose to you. I mean, this isn't
I'm so excited.
Yeah, this isn't even discovery. These are initial disclosures, right? Mm-hmm. Initial disclosures in federal litigation basically occur relatively early. You don't have to wait for a request. You basically supply all of the evidence and documentary evidence, tapes, and whatever that would tend to support your claims or defenses. So this is material that arguably Strickland's attorney should have turned over early on. So it begs the question, Dan, given that this information and this evidence comes from Strickland's own body cam, this to me raises the specter of Rule 11 sanctions against the attorneys for Strickland that signed the federal court complaint, that allege or that assert that Ujiri was the aggressor. So what do you think about the prospect of sanctions here?
Couple things, and I think it's probably important to give one level of background to this, just so people are aware. I mean, part of my background with the Giants that Dan mentioned, I worked in public relations. The non-sexy part of my job was issuing credentials to appropriate personnel and then reviewing them, different color credentials to get in the field, different access. So the initial story here, pre-lawsuit, was that Ujiri was trying to get to the court without showing his credential. And to the extent, right, if you're just some random guy, even if you're wearing a suit, and Ujiri was wearing a suit, which is important, not everyone's wearing a suit at an NBA game, so that should have probably given you some cause. But I guess the allegation was Ujiri tried to get to the court and didn't show his credential. Now, if we watch on this video, Dan, it's very clear that as Ujiri is walking over, he's reaching into his shirt for something. And actually, as he's pushed the first or second time, the credential actually comes out.
That's
and
a good credential. It pops out on contact.
Well, no, the lanyard popped out, not the actual thing. But also, if you're just watching the court, there's an NBA player that then comes over. I don't know if it's Lowry, but maybe it's even Kawhi, but I'm not sure who it is. But they come over and they get Ujiri. On all levels, Dan, it's pretty clear if you watch the video, Mr. Strickland realizes he messes up. He messes up either when the credential pops out or when the Raptors player goes to get him. Or, Dan, when you just pushed an individual for 2 times for no apparent reason, Ujiri was not being hostile. By all indications, this does appear to be a violation. And I have to imagine, Dan, his attorneys saw this video, unless Strickland, the only version I could say that you get the attorneys off the hook is if Strickland was hiding this video the whole time, and it's now only the first time is today or this past week or so when Strickland's attorney saw it. But they had an affirmative obligation to, I think, as officers of the court, to advise the other side of this as soon as they saw it.
The body cam is the property of the Alameda County Sheriff's Office. I don't think this was something that Alan Strickland had within his possession. And if I put myself in the position of the lawyers who are certifying that the complaint is basically the factual contentions are backed by evidence or will be backed by evidence following a reasonable opportunity for discovery. I mean, the lawyers that filed this, it's a major law firm in Sacramento, California. All they do is personal injury and employment law, 50, 60 attorneys. They've been down this road before. They're not newbies. So I would think that when they filed the complaint, they probably didn't have reasonable access to this body cam. Otherwise, they never would have.
I'm going to agree with you. I'm going to agree with you because I'm just from, Dan, 90% of my cases are just pure civil litigation cases. I have the defense of those cases. Sometimes I have some of the, I take them on the prosecution side. You don't always have all of the evidence. So if Strickland was saying he pushed me twice, and that's all you're going off of, and you have to make a version of request to get something from his employer. I don't necessarily I think the lawsuit, Dan, was filed, I believe, at the end of 2019. And this incident happened in June. Kind of a quick turnaround relative to how the sheriff's department might work. It's very possible they didn't have it, but I would think, COVID didn't hit until March. I would think they would have it sometime, February, January. It doesn't really make sense to me that this is the first time they've seen it.
Yeah, because if you're the Sacramento law firm that filed this case, the first thing you ask your client is, would it be okay if we, if we took a look at this body cam, and would you ask the employer, would you waive the, any kind of objection to it? And as an attorney, I'd want to see this body cam. So it really does place the lawyer in a difficult position, because if there's that amount of time that was spread between the game and the filing of the lawsuit, there would reasonably have been ample time for the attorney to conduct his due diligence investigation. So, maybe we're looking at a Rule 11 motion coming down the pike in less than 21 days, because as you know, under the guidelines, you can't file those right away. You have to allow a cooling off period in which to give the other side an opportunity to withdraw the offensive pleading. And this leads me to my practice tip for you young ones out there who have crazy clients or clients whose stories may not add up. And this happens a lot in family disputes, partnership disputes, divorces, personal injury cases. If you're a junior associate, Do not be the signatory of the complaint. Allow your partner, the supervisor, to be the signing attorney. Because I could tell you from personal experience, being the only person to sign the complaint carries with it a risk that you could be the one left holding the bag.
Kind of one interesting note that I don't want people to take for granted in the story. And Dan is right. It's not the first time in the history of the law where someone made a claim that we'll say wasn't necessarily true. But of that, we'll say that like Venn diagram, right? If there's the people that aren't necessarily true, there's only a very small subset that there is some type of evidence, be it video evidence, documentary evidence, that completely contradicts their case. I mean, there's a whole industry of people that we'll say have claims that are loosely insurance fraud, but there's nothing really to back it up. But this is, to Ujiri's extent, and I think important to bring up. Ujiri had a comment that I took a lot away from. Ujiri, was saying if this had happened to somebody else, right, that didn't have the means or the profile or the stature that I do as there's a Toronto, Raptors GM. I mean, it's great for me, but he goes, it's just not fair that it took my resources and my level of stature to avail myself to this kind of defense. I'll push back on Ujiri's comment a little bit because, Dan, as you and I are pointing out, this is just basic federal discovery. For their failure to disclose this would have been unethical, to risk sanctions with the bar if they didn't provide this. So I think the video doesn't really have anything to do with the quality of his own lawyering. But I will say, I understand the point that he's getting at, but I don't think, Dan, if you had like Mr. Magoo as, Ujiri's lawyers, the video still would have come out. It's the affirmative obligation in federal court for the plaintiff to provide those materials. It's not like in most cases in state court where you actually have to make a discovery demand to get the video. This is more one-sided that, Strickland's attorneys had to provide that on their own.
Yeah, I'll leave you with one. And before we move on to our next topic, I want to leave you with a prediction here.
Wait, time out. Do we have a special sound effect for your predictions? Because you're like undefeated in these.
I'm on a roll. I mean, I'm fresh off the heels of The Rock having some insider claim creditor issues. I'm going to move on to my next prediction. We haven't seen the amended answer. I'm not sure if the amended answer was filed as an exhibit here, but if leave to file one is granted by the court, I wouldn't be surprised if Ujiri adds a Section 1983 claim and brings in the Alameda County Sheriff's Office under a Section 1983 municipal liability theory based on failure to train, failure to adequately supervise. I mean, when you see some of the public comments that have come out from the sheriff's office, they instead of agreeing that this looks really bad, the sheriff's office's public statements still support Alan Strickland, and the spokesperson who is quoted said, well, it only shows snippets of what actually happened. It needs to be viewed in context. And if I'm Ujiri and he was wearing a uniform and there's some training deficiencies involved here, and maybe there's a track record where he wasn't adequately disciplined in the past when he should have been, maybe this could give rise to a muni liability claim under a Section 1983 theory. So that's my dark horse prediction for this case coming down the road. I know it's a real long shot, but I think it might fit here.
Well, Dan, you're always right. So I mean, it's not really a dark horse; it's just inevitable at this point.
I mean, I could make the easy predictions. This is one that's not the chalk. That does require some thinking outside the box. And having done my share of Section 1983 litigation on the civil side, I think you could at least get a failure to train, failure to supervise claim beyond a motion to dismiss. So let's move on.
That'll take us to the second topic that we wanted to get into. That is Earl Thomas. Earl Thomas is making, we'll say, headlines for the wrong type of reasons for the second time in, I think, since COVID. The first time you might have heard Earl Thomas's name, we'll try to keep this PC, but Earl Thomas was involved in a we'll say, a bizarre incident involving his brother, a female, and something going on in a bedroom. You can use your imagination, but the police were called because, we'll say, somebody walked in on this thing happening. So yeah, that's the first Earl Thomas news we heard. Earl Thomas is obviously a fantastic football player for the Seattle Seahawks for many years, now with the Ravens. And now Earl Thomas came across our Twitter feeds once again because the Ravens have, by all indications, said that they are moving on from the Earl Thomas era, which was very short-lived. When I see the word conduct detrimental, of course, Dan, I think of this podcast. And then, Dan, when I see that potential millions in guaranteed money might be lost because of the terminology in this personal conduct detrimental clause, then I know it's going to be a topic on the show. And wouldn't you know, Dan, I have my own predictions. I predicted this was going to be on, and guess what? I am right. Dan, what do you have to say on this Earl Thomas issue?
Well, I mean, your prediction actually has to be on a prior episode in order for it to count.
That's not true. That's nowhere in our bylaws, Dan. That's not really that fair.
Well, in many ways, this is like an Antonio Brown case, but without the signing bonus, which does, raise a lot of questions. Earl Thomas got into a fist fight with one of his teammates, and I would think that the Baltimore Ravens aren't going to base a conduct detrimental termination without pay on just simply a training camp fist fight, because anyone who's a fan of the National Football League and follows training camp for all of their teams knows that fist fights in training camp are a rite of passage. So they're going to try to portray him as a malcontent, somebody who was disruptive inside the locker room. And I think the posting of these or the practice tapes on his Instagram account might be the straw that breaks the camel's back, because if Earl Thomas had just stayed quiet and only gave the Ravens the fight and maybe some accusations that he's a malcontent, I don't think that would have been sufficient to constitute conduct detrimental under his standard player contract, because you need to have something a little bit more than just training camp fights. And he may have unwittingly rescued or just clutched defeat from the jaws of victory by posting those practice tape videos on his social media account. So what do you think about that? Do you think he's got a good case or a not so good case?
I mean, it's going to depend, at least in part, on what the Ravens' personal policy is. I can't imagine that. I mean, we don't see that many videos in-house from players, and I know that's, at least from what I knew with the Giants, it's very much looked down upon. So, if the Ravens have a policy that says that you can't be sharing those types of materials,
do you really need a policy for that?
I mean, it's always. I mean, Dan, listen, you're calling me out on my prediction thing, which is not in writing, so I can make up the rules as I go. That's why you put things in writing. That's why you hire lawyers to write the policy for the team and what they can and can't do on campus. So to the extent that Earl Thomas potentially put out a video that he wasn't supposed to, I mean, that's one thing. I mean, I've seen, in this past couple of years, there's videos taken in the locker room after games are over and players might be caught cursing. And actually, you know what, Dan, I take one step back. It's actually an Antonio Brown thing I'm remembering. When he was with the Steelers, he recorded, I think he recorded Mike Tomlin in the locker room afterwards, and he got in trouble. So is it an offense that should get you kicked off the team? I'm not sure it should, but I will point out, Dan, I don't think it's a good look for Earl Thomas to be litigating this case on Instagram, just like he was trying to litigate these crazy allegations with his brother and the girls on Instagram. So I don't like it, just like, and we'll talk about with Katie Strang with Mike Milbury. I don't know if this is just one incident. I don't think that that's why the Ravens would be ready to cut bait with Earl Thomas, a fantastic talent, so quickly. I tend to think that this might be the accumulation of incidents that is leading to this.
Yeah, I think we've got to look at, and when we speak about Milbury, it does raise the questions of selective enforcement and past practices and how an employer has treated similar situations in the past with respect to other players. And, I found something in doing some of my research for tonight's broadcast. I was trying to gauge some of the fist fighting and some of the training camp fist fights that have occurred throughout the past few years of Ravens training camp. And there was like this all-out brawl in 2016, and John Harbaugh was interviewed by the news media in the aftermath of this big, spate of training camp fist fights. And he said, this is what it's all about. We've got a bunch of young guys that like to play and want to get after it and have a lot of pride. It's a tough game. And I did like the spirit and physicality. Well, how do you square those prior incidents and those comments? And how do you reconcile that with taking an adverse action against Earl Thomas today based predominantly on a training camp fist fight? I think what the Ravens might actually try to do here is build a stronger case based upon some of these other factors I alluded to earlier. But if we're going to have equal justice and consistency with past practices, I think it's fair game to look at how similar situations were handled in the past, not just the fist fights in prior years, but how the team dealt with Ray Rice initially by, not taking any adverse action against him, and then only much later on doing so. So this may set up a very contentious grievous proceeding, but at the end, we're not talking about the bulk of the money under his contract. He signed a 4-year, $55 million deal. 32 million of which was guaranteed, but 20 million of that was in the form of a signing bonus. And even though that's allocated over 5 years and paid out over 4 years, not 5 years, signing bonuses are deemed earned when the contract is signed. And under the collective bargaining agreement, there are only 4 circumstances under which a signing bonus, even an unpaid signing bonus, can be clawed back. That would be if a player holds out, he retires, he shoots himself in the leg like Plaxico Burress. But conduct detrimental isn't one of the grounds for clawing back the signing bonus. So of his $55 million deal, $20 million is already earned. He made his $2 million in guarantees last year. So the only guaranteed portion that remains is the $10 million for 2020, because 21 and 22 are non-guaranteed years. So I think it's worth filing a grievance. And considering that he's made $22 million for 1 year's worth of work, when you assume that he's going to win on the signing bonus aspect of it, I don't think he has anything to lose. And he's in a pretty good position to win the case, and certainly to make up some of the lost earnings, maybe by signing with another team. But this is not a major dollar amount like the Antonio Brown case was. This is really about $10 million, which is roughly 18% or 17% of his total contract value.
I think it's a good place to end this, Dan. And obviously, we don't know everything yet on the Earl Thomas front. There is more, Dan and I will be updating you on that. So that'll take us, Dan, to our third topic. That is going to be the update in the Robert Kraft case. So for those that don't know, just a quick background, I have the ability to at least see most of these arguments. It wasn't so long ago. I believe it was maybe early July, but they posted the link live. And one of the benefits to living in this, probably Dan, the only benefit to living during a pandemic is that a lot of these things are on Zoom that you and I wouldn't otherwise be able to see live. So Zoom, credit to you. You've made the pandemic a little less worse. But for those that are kind of following this case, Robert Kraft was caught in we'll say a massage parlor or whatever you want to call it. As he was at the parlor, or whatever you want to call this, the spa, there was video surveillance being taken of the guests inside. And so in order to get that access, that surveillance footage, there had to have been a subpoena that allowed that access. So as Robert Kraft left the facility, a police car found him and arrested him. And that is the nature of this case. So when the case was at the lower court, there was a battle over the evidence. And the question was whether that surveillance footage, whether that was allowed to come in or whether it went beyond police authority to conduct the surveillance, whether the subpoena didn't cover necessarily what it should have done. So that's what's called in the law, Dan, obviously the fruit of the poisonous tree, whether or not that should come in if it wasn't adequately covered by police's authority. That was ruled inadmissible at the trial court level. It went up on appeal, and that's the decision we're going to talk about today. Robert Kraft, if the evidence comes in, all of a sudden there's a pretty strong case at the lower court, but without that video, it's going to be really hard to prove that he was there, Dan. So why don't you fill us in on the update and where it goes from here?
Sure. This is a case that's not only about Robert Kraft. It was part of a series of consolidated appeals involving other defendants. And this is a case of first impression in the state of Florida. Florida court has never before answered the question that's been burning on our minds ever since we went to law school, which is, do you have a reasonable expectation of privacy in a massage parlor?
That is not burning on anyone's mind, Dan. Who do you think we're talking to?
Well, there are scant few cases in U.S. jurisprudence which assess the reasonable expectation of privacy in and around massage parlors. There's a case out of Maine. There's an Alaska Supreme Court decision.
Did you just say that question was burning on our minds since we got to law school?
Your mind, not mine.
You said our minds. I don't think like that. Don't bring me down to your level. Okay, keep going.
I only became married. I only married my wife a year ago. So up until a year ago, I never had any reason to go to one of these places. So I'm
just remember, this is all being recorded. Okay, just so you know, you have no expectation in privacy about what you're about to say. But go on.
So the truth is, the really fascinating thing about this case is that the Florida 4th District Court of Appeal ruled as a matter of law that a patron in a massage parlor, in a private public room in the massage parlor with the door closed, has a reasonable expectation of privacy under the Fourth Amendment.
As they should. Independent of what you're doing in there, if you're doing anything illicit or you're just getting a massage, God forbid, you should have an expectation of privacy.
Wait a second. This is not the massage room at Equinox. This is a massage parlor that is accused or at least suspected of being a front for a brothel. So you can call it a massage parlor, but if it's in reality a brothel, do you have a reasonable expectation of privacy in a place that has sort of a mixed use like that? Because some people go there for legitimate massages. Some people go there for what I would call massage plus. And that's really a fascinating legal issue, which is why I believe this case might be headed to the Supreme Court of Florida, because it does impact the permissibility of law enforcement using these novel eavesdropping techniques, surveillance video in private/public places to catch people who are in the midst of committing crimes. Because with the crime of prostitution, the last element of the offense isn't committed until the money changes hands inside that public/private room. So without the ability to utilize this kind of surreptitious surveillance evidence, a lot of cases would fall apart. And I think it's important enough to the state attorney's office, because this isn't about Robert Kraft, but could potentially affect hundreds of cases going forward, not just those involving prostitution. So there's that issue. And then there's the issue of minimization techniques. The reason why the court found that the conduct of the state attorney violated the Fourth Amendment is that the prosecution or the police officers didn't use sufficient or employ sufficient safeguards to minimize the intrusion on people going there for lawful purposes. So for those who went there for legitimate massages, well, they were caught on videotape as well. And Kraft was arguing the constitutional rights of others in seeking the suppression of this evidence. And I think it raises the question as to whether Florida law requires any of these minimization techniques, because there is no case law, no statute under Florida law that addresses this precise situation. It's only U.S. Supreme Court precedent. And I know from litigating cases in Florida that it's textbook law that you do not have the right to assert the constitutional violations belonging to third parties. You can only assert the violation of rights pertaining to you. So I think this isn't the end of the story. This is what could be the beginning of a slightly bumpy road, which means that this could be in the news for another year or two, because we've got in my view, four gauntlets to run here. The state attorney will file undoubtedly a petition for rehearing en banc to have the entire case reheard by the full Fourth DCA. 3 judges heard this case and decided this case. You're entitled to have the entire 4th District Court of Appeal review it with all of the judges. So that move or that next shoe is going to drop within the next 15 days. And then afterwards, I would expect the prosecution or the sheriff's office to file a petition seeking review with the Florida Supreme Court. So I think these are teed up to be very interesting issues of first impression in the Florida courts. And I don't think it's anywhere near over yet.
I have a question for you, Dan, because you had a question for me before. I don't know if I feel that strongly about it, but I think it's just worth bringing up for the purposes of the podcast. We talk about conduct detrimental. My general sense is that I think it's the worst kept secret in football and any type of sport. What a player does is going to get more scrutiny than what an owner would do, because the owner calls the shots. They run the show. At no point, as far as I'm familiar with, has Bob Kraft ever contested the validity of these videos, if it's actually him on video. I think he's pretty much owned it. To the extent that this video, right, like it comes out or we all see it and it admits it in open court that it's him, is there any chance, in at least how you view this, that Bob Kraft could be in any way, shape, or form at risk of punishment, A, by the NFL, or B, the nuclear option, that he could potentially be at risk of losing the team?
Well, the latter is definitely not in play here, because if you were going to prosecute every septuagenarian who went to a massage parlor for sex, you really wouldn't have anyone left.
What is a septuagenarian?
Some guy in his 70s.
That sounded like
big
really
word.
Inappropriate, but keep going. Yeah.
I
don't know what that means.
Word. I don't think the issue is losing the team here. I think the bigger issue, besides the case and winning on the merits and getting this video suppressed as a matter of finality, is it's not just the criminal case that is at issue here. There's also the potential for parallel investigation by the National Football League. And let's not lose sight of the fact that a number of news organizations, including the Boston Globe, the Boston Herald, Fort Lauderdale Sun-Sentinel, it's a very long list. They've made requests, Freedom of Information Act, public records requests for copies of these videotapes. And the 4th DCA's ruling only addresses whether the video should be suppressed in the criminal case as a violation of the Fourth Amendment, we still have the looming issue over whether this videotaped evidence should be released to news organizations as a public record. And I could see the merits both ways. If you're Robert Kraft, it's fruit of the poisonous tree, an illegally obtained video in violation of one's constitutional rights should not necessarily be released to the general public. But on the other hand, the court's reasoning was based upon Fourth Amendment issues, not right of privacy issues. So I think we may be headed to another legal battle, not involving the NFL necessarily, but news organizations arguing that they should have access under Florida's broad public records law. That aspect of the case may have a separate life of its own. And I'm not sure that the news organizations are in the wrong here. I think this is fair game as a matter of open and fair access of Florida's public records laws. And I think the merits or the equities lie on the side of open access rather than restrictions.
I mean, we'd be remiss if I didn't bring it up. I mean, obviously, I don't actually think he's going to lose the team, but I do think punishment is in the realm of possibility. Jim Irsay, the owner of the Indianapolis Colts, had a DWI a couple of years back, and he was found with pills in the car, enough that it was a reasonable expectation that he might have been selling them. I think it's, apples to oranges, whatever, metaphor you want to use here. Being caught in a massage parlor, doing whatever you were doing in there, whatever illicit acts you were doing with prostitutes, whatever, that's not a good look for an NFL owner. So I would be, if I'm Roger Goodell, I mean, you never know what Goodell's going to do. He's going to get bashed if whatever he does one way or the other. But I do think there's a very realistic chance that Kraft could get some type of suspension here. I think Irsay got a suspension for 5 games, and I believe it was a couple $100,000 in fines. So I don't think this is so. Maybe it's not as bad. I don't know how to compare the two. A DWI with intent to sell prescription painkillers or going to a massage parlor and doing something illicit. I think they're both in the category of things that you could get suspended for. So Dan, that's my prediction, and I'm going to nail both of these because I already got one because I knew we were going to talk about Earl Thomas. Okay, Dan, I don't have anything else on this topic unless you do. I'm ready to wrap this third one up.
Yeah, I think Mr. Kraft is ready for us to move on as well because we've just revived all these issues that are going to be lingering in his legal affairs for at least the next year or two because this thing's not going away. And I would not be shocked if the result is different by the time the Florida Supreme Court addresses this. As we transition into the sensitivity surrounding our last topic, which is former New York Islander general manager and current NBC broadcaster Mike Milbury's misogynistic comments about women being a disruption. I mean, we're going to, maybe we should just replay the comment, but I think we could all agree it was fairly misogynistic, very misogynistic, and it's a continuation of a pattern of not just casual misogyny expressed by Milbury, but I think over his career as a broadcaster, he's really had a number of issues that have popped up with comments that could be, reasonably viewed as being offensive or being inappropriate or not enlightened. And this is just the latest in a long litany. And we're going to bring on one of my colleagues at The Athletic who writes about hockey. Her name is Katie Strang. She's a senior writer for The Athletic, and she wrote an incendiary piece in The Athletic on Friday in which she basically said, enough of this already. I'm mad as hell, and I'm not going to take it anymore. It really unleashed all of her frustrations with how women are treated by Milbury on the air and basically the culture of hockey possibly being responsible for this. And with all the gains that the NHL and hockey have made in recent years to be inclusive of women, and we're now seeing prominent women in roles in broadcasting and being game analysts, analytics people, scouts. Every organization has made strides in advancing the cause of women in hockey. And in one fell swoop, Mike Milbury, sets back the movement, at least, in terms of the optics of it this weekend. So we're going to talk to Katie about her article and essentially how she feels the Milbury situation should be addressed.
And just one note before we kick it over to Katie, I think, and again, we'll talk to Katie about this, but there are comments from Stephen A. Smith with regard to the NBA's bubble that players front and center on their minds was that they're not going to have access to Instagram models or the casual relationships. They weren't allowed access to the nightlife for women outside of the bubble. So Stephen A. Smith was very vocal about the comments. He said them in kind of a tongue-in-cheek way. No punishment came for Stephen A. Smith. So Dan, I'm not the biggest hockey fan. I know you guys and you and Katie are both going to be very familiar with Milbury's comments. I heard the comments in isolation, and I didn't think they rose to the level just in and of themselves where he should be fired. But I think it's important for those like myself who just read those, it's important to kind of sit back and read what else has been out there. As Katie and Dan, as you've advised me offline, there is a longer history of this. So you can't just judge the one 16-second clip in isolation, which I posted. There is a longer history, which...
Yeah, but Dan, we can't necessarily drop the bomb on Mike Milbury unless NBC had issued warnings with respect to some of those past incidents. If he just stayed silent and didn't say anything to him internally, and there were no notices or, you're on probation or this or that, I think it would be unfair to basically utilize all those past incidents, prior instances, and say, okay, now, when you look at them in the aggregate, there's no way we can hire you back. Listen, as a private network, they can hire and fire whenever they want. The question is, do they fire him with cause or without cause? And in my view, this was not a with cause terminable event. It was an offensive comment, but I've heard worse. And I think Katie's right about what she wrote in her piece in The Athletic. You're going to find a cross-section of views along the Twitterverse on this issue. But I think instead of firing somebody every time something like this happens, unless it's just so egregious that you have no choice. I think this could be a moment in which instead of firing somebody, we could sort of rehabilitate. And I think Milbury realizes he screwed up. And I always viewed Milbury as being an A-team announcer or an analyst. And then somewhere along the way, these incidents just keep cropping up and it becomes almost an indictment against him. So I have mixed feelings about this. I'm not sure it's a terminable event, but it is a thought-provoking discussion with our next guest.
And with that being said, let us turn it over to our interview with Katie Strang.
Our guest today on Conduct Detrimental is senior writer for The Athletic, covering the sport of hockey, the one and only Katie Strang, who has written pretty explosive article and I would say one of the strongest pieces I've read on the situation around Mike Milbury. Katie, can you give me a little bit of context as to what led you to write a piece in the style in which you wrote it, in which it's really like a no-holds-barred expression of your frustrations with Milbury, NBC, and maybe even the sport of hockey. So could you walk me through your process as to what led you to write it in this style?
Sure. Yeah. So my primary role for The Athletic is I am a senior NHL writer, but my sort of primary bread and butter role is I'm an investigative writer. And I cover a lot of the intersection of social issues with sport. But sometimes if I am so moved, I will, weigh in and write a column. It's pretty infrequent, I would say. So if I feel I will weigh in. I don't do it often because I don't like to have to manufacture an opinion. But this one I certainly did not have to manufacture. And just to kind of give you some context, I had heard about the comment, almost in real time, and was upset by it, but kind of just rolled my eyes and went to sleep. And I kind of revisited it the next morning and was talking to some friends in hockey. And, I had this sort of reaction of like rolling my eyes and being like, yeah, I'm not surprised that he said this, just given, the history of some of his comments, and he can be pretty polarizing and incendiary at times. I was not happy with the remarks that he made directed toward Tuukka Rask earlier in the playoff series. And so I found myself almost kind of treating it with a sense of futility, which was just like, that's Mike Milbury. Like, this is what we sort of come to expect. And then I kind of like took a step back and started to reflect. And I thought, maybe I'm kind of part of the problem too, if I'm just, kind of throwing up my hands and expressing a sense of futility, that this is just what we've always sort of come to expect, and that this is what we should live with. And, I thought that was, kind of unfair that, I, to be quite frank, I thought that's like the easy way out to think like that. And I'm like, you know what? I expect better from myself. And I want better for the sport. And I don't think this is the best we can do. And if it's not the best we can do, I think it's fair to ask for more. And so that's what, prompted me to write that column.
Now, Milbury is, he could be accused of a lot of things, right? He's a bully, and we've seen instances of that before. He's made other misogynistic comments in the past and has spoken ill-advisedly on the situation involving Tuukka Rask, European players. The list goes on. And if you're from Long Island, you certainly have issues with Mike Milbury for trading Zdeno Chara and Ole Jokinen and Roberto Luongo. I mean, his list of transgressions is a mile long. Do you consider this to be a Mike Milbury problem, or it shines a brighter light on some of the frustrations you feel or see with regard to how hockey is covered on television and in the media and even within the game itself?
Yeah, I do think there's some sort of, cultural gatekeeping that takes place, within hockey, also within any sport. But I also think that's way too reductive and simplistic to say, because my experience covering hockey has been overwhelmingly positive in terms of the way I feel like I have been, treated with professionalism, respect, dignity, kindness throughout my career. And, because of that, do I think there's, some toxicity and some sort of systemic cultural issues? Absolutely. I think that's probably true of any sport. I think the difference is right now we are sort of at a cultural reckoning, if you will, about, what we want our sports to look like and whether we want them to be a reflection of society as a whole. And I think society is changing. So do I think that there are some problems within the sport that are much larger than Mike Milbury? Absolutely. Do I think even within the broadcasting community, we've seen this bubble over, within the last year? Absolutely. We saw it with Don Cherry. We saw it with Jeremy Roenick. We're seeing it with Mike Milbury now. But, one thing that I really did try to stress in my column is that, if this was just sort of like an isolated slip up or an errant slip of the tongue, if he came right back on and said, hey, you know what, that was out of line. I'm really sorry. I imagine that was really offensive. I take full ownership. That'd be one thing. I think we're all human. We all screw up at our jobs. I do all the time. And so I think there's a certain leash that you want to provide people and some grace that you want to provide them with as well. But with Mike Milbury, I really do think that this was not an isolated comment, but that this is indicative of a pattern of behavior.
So, it's funny. You kind of bring up just where I was thinking we would go. I mean, it's not every day. I mean, I posted, the fact that, and for those that are listening now, Mike Milbury is no longer going to be on the NBC Sports call. And he announced that it was his call. I'm not sure how much of that was mutual, but, at least what I think is important to highlight, if this was the comment in isolation and there was no history and no maybe, we'll say gray comments, do you think this would be to the level it is today if it was just that one comment?
No, I don't. And, if this was someone who, you look at the totality of his career, had not, had sort of a long track record of these comments, I don't think it would be, and I don't necessarily think it should be. I don't think that we should excoriate someone for one mistake, especially if we haven't given them the chance to learn and reflect and listen and evolve. But the fact of the matter is this is like the fourth or fifth comment within this playoff series. So that to me reflects either sort of a lack of self-awareness that what he's saying is offensive, or, an unwillingness to learn from those that are saying, hey, I don't like these comments and how this reflects on the game, and just, sort of, having a blatant disregard for, learning and improving.
My sense of how the public reacts is really, as crude as it might be, is just my Twitter replies, what people are kind of saying. And a lot of, just kind of nature of it. A lot of non-hockey people are weighing in on this, not knowing anything about the history. And I'm seeing comments like, well, and I'm not sure if you're familiar with it, but Stephen A. Smith had we'll say a similar comment about the NBA bubble, that he knows that, that players are going to break it because that's just what they do. And that's how they live on the road. So there are some people comparing, what is so different from what Stephen A. Smith is saying, and maybe in a higher level role at ESPN versus what Mike Milbury is saying. Now, I think the difference, and you can correct me if I'm wrong, Katie, I don't think that Milbury, I think that at least the part that I was looking at from my vantage point as probably the more offensive angle of it, is that he is kind of, it's not just NBA or NHL players trying to, have part of the nightlife. It's talking about no females at all within female reporters, anything like that in the bubble. I think that's the part, and you can probably speak to it as well. But that's the part I think there is a difference between what Stephen A is saying and Mike Milbury is saying. Stephen A is specifically talking about nightlife, where Mike Milbury, it just doesn't seem like there's any qualification on that statement.
Yeah, I think, the reason that it sort of veered into like misogynist territory is exactly what you're identifying. And it's hard for me to speak intelligently because I'm not super familiar with the Stephen A. Smith comments and I don't want to speak about them out of context. I certainly think it is fair for an announcer to highlight and discuss and dissect the challenges of a bubble atmosphere for professional athletes, whether that be in the NBA or NHL or the WNBA or any bubbles that we'll see in the future, and that these are young athletes, and there are sort of some challenges that it creates in insulating them in such a strict atmosphere. I think that's totally fine to discuss. But when I think that you make a joke, which he did say that it was an attempt to be irreverent about women not being around to disrupt arbitration, to me that's really degrading toward women, to sort of ascribe a very one-dimensionality to women. And I also think it's very insulting to players to ascribe this one-dimensionality to them as well, and to make certain assumptions about their behavior and their priorities that, quite honestly, in my experience covering hockey for 12 years, absolutely does not hold true.
Katie, I want to talk about NBC's role or inaction in this. NBC had another announcer that they suspended and fired, Jeremy Roenick, for making sexually provocative comments about several of his coworkers. They took adverse action against him immediately. But in the case of Milbury, NBC allowed Milbury to control the narrative by letting him issue a statement in which he removed himself from the balance of the NHL playoffs. It was coordinated through NBC, but you think NBC is complicit in this and not taking it seriously enough by treating adverse comments about coworkers worse than an entire gender?
Yes, I do think NBC is complicit in sort of emboldening Mike Milbury to think that he can make these sort of comments with impunity. And the reason why is exactly what I was saying, which is, this wasn't the first time this has popped up. This isn't the second time this has popped up. This isn't the third or the fourth time this has cropped up. This is, again, a pattern of behavior. And so, yes, obviously Mike Milbury assumes responsibility in this situation. But to some degree, if he continues to be empowered to make those type of comments and insensitive commentary, then it is also incumbent upon his employers to realize the implications of that and assume responsibility as well. So, I understand that Sam Flood, who is Milbury's boss, is very, very loyal to his broadcasters. I do not fault him for that. But in this event, I do think he's going to have to ask himself some really hard questions about, whether Mike Milbury can evolve and can, avoid offending large swaths of the hockey watching population in the future. And if he can't, then I think Sam Flood has to make a decision about the direction his broadcasts are going to go. But if he decides to stick with Milbury next season, and I don't know what the calculus is there, and this continues to happen, then absolutely he bears responsibility.
So I think that kind of the next natural question that would come of it, and Dan, I'm only laughing because Dan, in the legal profession, Dan might have asked the leading question there. I feel like I knew what Dan was trying to get to that one. But, the point is if Milbury is allowed to leave the bubble on his own, and he's not fired, right? He's not kicked off of air. That in theory leaves open the possibility that Mike Milbury can return when he wants to return. The question is, should he be allowed to come back either in the bubble, and it's not in the bubble, under what terms should he be allowed to return to the booth?
So my understanding is that he's not going to return to the bubble for the remainder of the playoffs. I don't think you would take that action unless you wanted to keep your options open for the next season. I think there's probably a hope that maybe some of the scrutiny and criticism dies down and that they can reassess their options at a later point. And, we will see what the future holds. And I think the question of whether he should be allowed back should probably hinge on two different factors. One, do you think he understands why he was disciplined?
Probably not, but
or incurred all this scrutiny, and is capable of changing or evolving, learning, showing a willingness to do the work. And two, the other factor that I think should be, obviously weighed is, are there better options? Are there people who, brings a certain sort of like charisma, hockey acumen, level of analysis, insight, passion for the game who need to weigh during this offseason?
Katie, I have one final question to take us home, and you've been very generous with your time. Thank you so much. When I grew up as a young teenager following the New York Rangers in the 1970s, one of the reporters who covered the team was Helene Elliott. And I connect with Helene a lot on Facebook, especially given our mutual connection with Barry Beck. And could you talk about your ascension into hockey and what led you to a career in the NHL and who you looked up to and anyone that might have served as your mentor?
Sure. I mean, Helene was definitely one of them. She was one of the, few women who were covering the game when I started covering the game. And Lisa Dillman as well, who is now, I'm happy to say, a coworker. And I had, a ton of really wonderful male mentors and allies as well, which, I think as we're discussing issues like these, I always like to sort of reinforce this idea of like, this isn't just like a woman's problem. This is an everyone problem. Like I heard from, I would say probably more men on this issue than I did women, who were like really happy that I spoke up about this, because I think there's been a general consensus about this sort of, swirling within the hockey circles for a long time. As far as how I got into it, I kind of back-ended into the sport, honestly. Like I became a sports writer with the intent of basketball were kind of my two passions. And I started intermittently covering the Islanders after Milbury's time had ended there, and got offered the Islanders B after a few years of doing that. But I think when I was around 25 or 26, and just fell in love with the sport and the people. And, I took a short detour into baseball for a few years when I was at ESPN, but was always just clamoring to come back into hockey because I loved it so much. And, I think if I had to sort of bring this topic full circle, I am critical of certain elements of sport because I love it. And I think it's really essential to hold the institutions that you love to a very high standard. And that is, part of the reason that I thought, it is not good enough for me to just roll my eyes and throw up my hands anymore. I love this game. I have to take ownership as a stakeholder in this game as well. And I have the right to say, I think we can do better than this. And so, but that really kind of takes me back to why I sat down and sort of started rage writing in the first place. Your column
has generated, I know I said last question, but your column has generated a lot of discussion, at least on my Twitter feed, especially out of Boston, where one of your colleagues in the industry, Kevin DuPont, I think he's with the Boston Globe, defended Milbury as, he might be an asshole, but he treats everybody the same. And even among some of the fans that were responding, there seemed to be a majority of them, or at least not fans, but followers, a majority of them didn't think that what he did or said rose to the level of being a fireable offense. So I think we could all agree what he said was misogynistic. But why do you think there's anything less than a consensus around what to do about Mike Milbury? I was surprised by how strongly some of the, contra views were on the issue, particularly from someone like Keith DuPont.
Yeah, and I think Kevin DuPont brought up some good points, and I, disagree. But, I think he made a point, and I've had several others make it to me as well, that Milbury was very fair to female reporters, even in sort of the dark ages. And I actually have heard that as well. I have not heard that Mike Milbury is a bad guy. I have not heard that Mike Milbury mistreats women. I haven't. But the fact of the matter is, that's, again, this is about standards, and I don't enough of a standard that we should expect from someone of that status. I expect Mike Milbury to not mistreat women. I expect Mike Milbury to treat women and women reporters fairly. I'm glad that he does that, but it does not, I think, preclude us from expecting that he does not make, comments that are misogynistic or, sort of, offensive across all spectrums, right? And I think what I think a lot of people who are sort of up in arms about this backlash towards him are debating is whether this isolated incident is a fireable offense. And I think they would argue that it's not. And I'm saying that it is. But I think the point that is being missed is this isn't an isolated incident. And I would not have written my column if this is the first time Mike Milbury said something of this nature. It's the fact that this is a pattern of behavior. And so when people show you who they are, you have to believe them. And he continues to show us who he is in the comments that he makes. And he does need to be held accountable for that.
Katie, we want to thank you so much for joining us and casting some light on a very important issue. Is there anything else that you want to send us home with? You've been a pleasure. We've loved having you on.
No, I appreciate you guys having me on and sort of letting me show you how the sausage is made on stories like these.
I know we didn't get to it, but I just wanted to say I read your article about Mario Lemieux's comeback, and I thought it was sensational. So you've been one of my favorite writers, and that was an exceptional piece going sort of on the inside of the comeback. So
that's Dan trying to sneak in a third question after he said fine 2 ago. But everyone's
I like it. That's my move.
Thank you very much, Katie. And I look forward, Dan and I look forward to talking to you again. And of course, I look forward to, speaking with you about other issues that we may or may not be working on together someday. So have a great rest of the day and we'll talk soon.
Sounds great. Thanks, guys.
Thanks, Katie. You. So that was Katie Strang with The Athletic. We're almost done. I just feel like we'd be remiss if we didn't hit some big topics for those kind of just trying to get the full landscape, what's going on in sports law. The story that I've been following, the big case, the Kobe Bryant wrongful death lawsuit, there was a motion in that case to take the case and move it into Orange County, an adjacent county from Los Angeles. The judge actually denied that, decided with Vanessa Bryant. I have more about that, at least on my feed. Kansas City Chiefs are taking a page out of the Redskins book, and they're rolling back some of their Native American imagery, also important. And Dan and I might touch upon that in a later podcast with some trademark issues over there. And I think the third one, Dan, you've been very adamant that you don't believe in curses. But I think, Dan, this NBA draft lottery with the Knicks dropping to the 8th pick, I think definitively shows that they're cursed. So I'm also going to take credit for that one, even though I didn't predict it, but I kind of did. So Dan, let me turn it over to you. Anything else before we put this episode in the books?
No. I want to add to your point. Of all the New York franchises, the Knicks are by far the most cursed. This is a team or an organization that had the chance. It was offered Dr. J, Julius Erving in 1976 when the ABA and the NBA merged, and they didn't want to pay $3 million to Roy Bowe, the owner of the Nets. And then the 76ers swooped in and acquired Dr. J for cash. I think the curse will eventually be lifted. And ultimately, though, you need a little luck. And luck has not been on the Knicks side lately in these NBA draft lotteries. But I will say that this is the strongest management team that the Knicks have had since the Pat Riley, Dave Checkett's, Ernie Grunfeld era, and certainly within James Dolan's ownership.
How many wins do they have, Dan?
They have 0 wins, but they also have 0 losses under this regime.
I'm just not that good. I'm not taking it.
But I like the hiring of Leon Rose. He brings in World Wide West. They bring in a stellar scouting staff. Tom Thibodeau, I love all of it. So the only thing that I'm really watching, and as a postscript to our coverage of the Masai Ujiri case, we're going to have a resolution of that motion to amend the counterclaim and answer to basically sue Alan Strickland. There's going to be an oral argument in the Northern District of California on September 22nd, which is probably going to be in about 3.5 weeks. And we'll learn then whether Ujiri will be able to move forward with his countersuit against Alan Strickland. And as I mentioned earlier in the podcast, I think it's a layup, and the court will likely grant it on good cause. And then we're going to see what this answer looks like and whether it extends into claims against the Alameda County Sheriff's Office. But that's all I have for the week. And it's just been it's like having to decide which topics to cover is always a challenge. There's never a shortage of them. And I hope that next week will bring at least as many interesting, diverse topics as this week. And I'm still waiting on a Zion Williamson ruling, and I'm predicting this will be the week.
So with that being said, we will put this episode in the books. As always, Dan Wallach is on Twitter and Instagram at Wallach Legal. Dan had a post on Instagram, which was shocking this weekend, first in a couple months. Myself, Dan Lust on Instagram, Twitter, at Sports Law Lust, the show Conduct Detrimental at Con Detrimental. And as always, if you can leave us a review, rate the podcast on Apple, would be very helpful again to everyone out there, and especially you, Mike Piazza. We'll see you next week.